This is a debate on motion 24260 in the name of Miles Briggs on a motion of no confidence. Could I call on Ruth Davidson to speak to and to move the motion?
Thank you, Presiding Officer. 3 years ago, 2 women came forward with allegations of sex. I move the motion in Miles Briggs' name.
Thank you. Can I call Deputy First Minister John Swinney?
Presiding Officer, on the occasions in which motions of confidence are debated, other ministers tend to speak on behalf of the minister in question. Today, I have chosen to speak on my own behalf. The decisions that are under scrutiny in this debate are mine, and it is right that I am accountable to Parliament for them. On the 4th and the 25th of November last year, this chamber debated motions calling on the Government to release its legal advice. On each of those occasions, I set out why Scottish ministers were asserting legal privilege. It is an important tenet of Scots law that protects organisations and individuals alike, allowing them the benefit of frank, confidential advice from lawyers. That is why it is a principle that has been upheld by successive Scottish and United Kingdom governments of different political parties. Ministers' view, my view, was that we could give the committee the information they needed to understand what happened in the judicial review while avoiding the precedent for future governments of waiving privilege. That is why I took the unprecedented decision to share with the committee in confidence in December, and this is where Ruth Davidson is entirely incorrect in what she said, a detailed submission that explained the content of legal advice during the judicial review. I believed then that such an approach could fulfil our obligation to Parliament and the committee without waiving legal privilege and therefore protecting the interests of future governments. Since then, we have seen outlandish allegations of conspiracy and corruption being promoted by people who, frankly, should and do know better. Those tactics require a response. We concluded that the debate those tactics provoked on Parliament's ability to scrutinise the Government and the accusations on which the debate was founded could impact negatively on public confidence in the Parliament, Government and even our judicial institutions. I therefore decided last week that the balance of public interest had shifted and we should publish the advice from Council. That meant that the process of release moved on to its second stage, consideration by the law officers for the first time. They consented to the release. We have moved as quickly as possible through the legal checks, having regard to the statutory obligations involved, before releasing these documents. Members will recognise the importance of those processes, not least to protect the identity of complainers. In releasing information, I kept in mind the committee motion explicitly sought 2 things: the legal advice of our external counsel and the associated minutes of meetings relating to the judicial review. The Government has now published all of the formal written advice notes received from external counsel. Indeed, we have also published emails from our senior counsel and an unredacted version of the summary shared with the committee in December. We have also published documentation that includes the legal advice of the law officers. On minutes of meetings, we simply don't have those. We have asked senior counsel whether they have a minute of these meetings. They do not. What I can say, there's an important point I need to put across. What I can say is that the outcomes of these discussions are reflected in the pleadings made to the court by the Government, which we shared with the committee some months ago. The documents we released confirm that in September the clear view of Council was that our prospects were good. They identified risks, these opinions always do, but it was a positive assessment of our case. As time went on and problems emerged, the picture shifted and external counsel became concerned and then alarmed. But as late as a note dated the 11th of December, the Lord Advocate was clear there should be no question of conceding. And even on the 17th of December, external counsel agreed that the case remained stateable. It was the note of counsel of the 19th of December that led directly to the case being conceded. None of this is hidden. In fact, let us be frank about what we have released. It paints a clear picture, warts and all. No embarrassment for the Government is spared in the publication of these documents. Indeed, Presiding Officer, it is worth reflecting for a moment on the significance of what the Government has done in this case. we have taken the extraordinary and unprecedented step of publishing formal legal advice of the kind which no previous government in Scotland has done, and we have done so in response to the request of the committee and motions passed by Parliament. On any fair interpretation of what the government has done, the Tories' pursuit of this motion today is now entirely baseless. With an election only weeks away, the reality, I suspect, is that they were always intent on pushing this motion to a vote, regardless of what action the government had taken. I have sought, Presiding Officer, to provide the committee with the information it needed to do its work. Indeed, we have supplied the committee with thousands and thousands of pages of documents. I have sought to ensure the government and all future governments retained its ability to take frank, unvarnished legal advice, and I have sought to meet my obligations to Parliament. There are always clearly conflicting judgments that have to be resolved amongst those three factors. It is now for this chamber to judge whether those actions, taken in good faith, are sufficient to command their confidence. This government has accepted, since January 2019, that mistakes were made in the handling of these complaints. As a result, 2 women were badly let down. The government must and will learn lessons from those mistakes.
Thank you very much, colleagues. That concludes our debate on the motion of no confidence. The vote on this matter will be taken at decision time, which is 8 o'clock this evening. We're now going to move on to the next item of business. There will be a short pause while we do so.